Okay, everything's working. I think we can then officially begin this meeting. So I want to thank everyone for being here today on a Friday afternoon. You could be a lot of other places doing a lot of other things, but I think the fact that we have close to 200 people registered for this conference shows the importance and the concern that the business community has with the issue of workplace impairment, especially as it relates to cannabis. I just want to go through a few housekeeping things first, and then we will start this session. One, everyone should realize that this meeting is being recorded. We will be sending out copies of the recording to all registrants next week, so you'll be getting a copy of this. Also, there will be press, on the call, so just to make sure that everyone, is aware of that. The way we're going to work, before we get any further, I want to thank our sponsor today, Parker McKay. Danielle, you want to throw back their slide for 1 second so I can officially thank them? Or maybe not, I'll officially thank them anyway. There we go. So we're going to thank Parker McKay for being the sponsor of the event today. We cannot do these events without our sponsors, so we thank them for helping to make this possible. The way I would like to run this for the next hour and a half, I am going to make some brief opening comments as far as introductions are concerned. I will then, introduce our speakers, across the board. Then I will turn it over, to the speakers to give, opening remarks. We're going to then spend hopefully the next half hour in a free-forming conversation. And then the last half hour, I like to be able to open it up to participants, on this call, or attendees, to ask their questions. The way I would like for you to ask your questions is to either drop it in the chat and we'll try and get to it, or you'll have the ability as well to raise your hand. And when I say raise your hand, it does not mean do this. In the Zoom world, raise your hand means go to reactions. Under reactions, there'll be a little button that says raise hand. Once you do that, you will then, a little yellow hand will pop up on your screen. I will be able to see it as it will move you to the front of the line, and I will call on you as we go along. Danielle will then unmute you when it's your turn to talk, and then mute you back afterwards. Danielle just also dropped in instructions to raise your hand. But I was saying before, hopefully after 2 years of Zooms, we all know how to work these little icons and little nuances of a Zoom meeting. So let's get into the substance. Prior to the New Jersey Cannabis Regulatory Enforcement Assistance and Marketplace Modernization Act, or CREMA, was signed into law in February 22nd, 2021, it was going through the legislative process. And we knew at that point in time that the business community was going to have concerns with how do we test for cannabis in the workplace, given all the limitations on testing and knowing whether or not someone is currently impaired on cannabis, or they had taken cannabis at a prior time, but it's just showing up, in the testing methodologies. We were arguing at that point in time in the legislative process, especially for safety-sensitive positions, that we err on the side of safety and that we allow a failed drug test alone to be determinative of impairment, which would have been a much stricter test than the law actually ended up happening or providing, but it would have erred on what we believe is the side of safety, which we think, again, is the most important factor. The legislature disagreed with our advocacy and instead put into the bill a requirement that you cannot rely on drug tests alone to take adverse employment actions against an employee who they thought was impaired, but that you had to do a physical examination as well and those physical examinations will be done by what is called workplace impairment recognition experts, WIRES. So when the law was passed, the WIRE provisions were in the law, and it was put upon the Cannabis Regulatory Commission, the CRC, to adopt regulations to certify WIRES so they could be then used by employers to implement the provisions of the law. For various reasons, and we'll get into this in a moment, those regulations were never adopted, and instead, the commission recently came out with guidance to help employers in the area of workplace impairment and maintaining a drug-free workplace. We have assembled a panel here today of experts in the field, including Chris Riggs, who I'll introduce in a moment, from the CRC, who will be talking about these issues. Because right now, even though, again, and we thank the CRC for working with us for the last couple of years, a year and a half, at least, in trying to resolve these issues, trying to come up with regulations that work for everybody. And we're appreciative of their efforts, and they're taking the step in issuing the guidance. I think what you'll hear today is that the employer community is still concerned with they have uncertainties as to what employers can and cannot do. There's concern about litigation. There was just a lawsuit filed this week involving Walmart and their drug testing policies. Perhaps we'll talk about as well later. There's some still unresolved issues in the state Supreme Court on drug recognition experts. We absolutely will be talking about that fairly soon. But, there's just a feeling right now as that employers, even with the guidance, are still uncertain as to what they should or should not be doing. Again, hopefully our panel today will provide clarity, or at least clarify what the questions still are. So having said that, I will stop talking. Let me introduce all three of our panelists first. I'm going to give very quick introductions, and then I'm going to turn it over to Chris first to talk about the CRC's WIRE and guidance provisions. So Chris, again, just very quickly, is an attorney. Obviously, he is the chief counsel for the Cannabis Regulatory Commission. He comes to us from the Attorney General's office, and then also from the Department of Health and Human Services. Also with us today, and I'm pulling this quickly. Of course, it's not working. Is Bo Hutch. There we go. Bo is of counsel of Porzio, Bromberg, and Newman, where he counsels clients on compliance and regulatory issues relating to the emerging cannabis market. And I'll just go quickly to Jeff Catalano, an associate at Parker McKay. Again, Parker McKay, we thank you for sponsoring today's events. And Jeff concentrates his practice in the area of public schools, education, labor, and employment. So again, I thank you all for being here today. And I will turn it over to Chris for opening remarks. Tell us what the CRC has done, has not done on WIRE regulations, what to expect, and talk about your guidance. Thanks for being here, Chris.
Very good. Thank you, Ray. Thank you, Bo. Thank you, Jeff. Happy to be here to talk about this today. It is an important topic that the CRC is concerned about. And we really want to be able to strike a balance between workplace safety, work performance, and an adult employee's right to privacy and consume cannabis during their off hours. I mean, that's essentially what the law says, and we're trying to strike that balance. The guidance document isn't going to supplement the WIRE regulation process. We are still in that process of determining the parameters of what regulations we need as far as just establishing standards and the curriculum for WIRES, the workplace impairment recognition experts. What the guidance is it's not regulation, it's our starting point. It's intended to clarify and explain the commission's understanding of the law and the legal requirements in the law. How do we get to reasonable suspicion of impairment? That's the question, right? That's the question that I think everybody needs to ask themselves when determining whether somebody's impaired at work. And especially in the cannabis world, because there is no currently reliable way to measure cannabis impairment as we do with, blood alcohol or blood alcohol content or something of similar nature. So what we did was we did some stakeholdering. We did some work with NJBIA. We did some work with employment attorneys. We did some work with other folks that are involved with the Department of Health to come up with a guidance document that, establishes that balance. It establishes the balance for, workplace safety, and also that employees' right to use cannabis in their off hours. We're continuing to work on the regulations behind the scenes. That work is not done. We need to continue our stakeholdering. We need to continue to talk to the relevant folks, continue to work with BIA to establish this curriculum process so that wires can be certified. But, we're not really breaking new ground here. We believe that impairment by cannabis should be treated no differently than, how employers are currently handling impairment by any other substance in the workplace. The key is to get the reasonable suspicion of impairment and to determine if an employee is unable to do their job or in a safe way. And that's really what the guidance is here to do, is to clarify that understanding under the law.
Appreciate that. Before I turn it over to Bo for his comments, I just want to not push back, but ask this question. There are a number of people who don't believe that the commission had the authority to issue the guidance the way they did. There's a reading of the statute that in order to take an adverse action, you have to do a physical exam, and that physical exam must be done by a wire. But yet the commission, what the guidance says, at least my reading of it is that the wires ultimately will be a way of doing it, but a reasonable suspicion criteria is another way that you could, another path forward for employers. So the commission's making a distinction and saying wires aren't the only way to deal with impairment issues. Can you speak to that?
Yeah, that's actually correct, right? Like we looked at the law and our understanding under the law and our interpretation of the law. The guidance doesn't give any additional rights. It's simply clarifying the CRC's understanding of the law. And, we believe that reasonable suspicion of impairment is the test. Wires are going to have to go through a certain, curriculum process that we're going to establish in regulation where they get certified to be a wire by the CRC. That term of art, physical evaluation, is really what the term of art is in the law. It's a physical evaluation is what a wire needs to conduct. You don't need to do a physical evaluation to get the reasonable suspicion. You can document observable signs that are uncharacteristic, dangerous behaviors, inability to carry out your work requirements and do your work to develop reasonable suspicion, which is ultimately the standard to take adverse employment action, coupled with those observable. So you'll have the observable signs to get to reasonable suspicion, and then you can have that scientifically reliable drug test, and then you can take adverse employment action.
All right, let me turn over next to Bo to give your opening comments.
Hey Ray, thanks for having us.
Bo, you're on mute.
Yeah. So going back to nobody knows how to still use this in this day and age. I'm one of them. Ray, thank you so much for having us. NJBI, thank you for putting this together. I just want to thank Jeff and Chris for actually taking the time out of their day on a Friday to do this. Happy Friday to those who are on the call, to those with family and friends in storm impacted areas. I think I speak for everybody. Our heart goes out to you. This is a really unique moment as to where we are as a state, where we are as a country when it comes to cannabis. And we here are talking today about, what's in the adult use legislation as far as workplace impairment recognition experts. And we're talking about impairment guidance. In the back of our heads, we're all constantly thinking about drug testing. Well, in 2018, the feds did something really interesting when they passed through the Farm Bill, which was they allowed for the interstate commerce of hemp, which allows for the interstate commerce of cannabis isolates. This is a big deal. These cannabis products and their hemp-derived products can trigger the same positivity in one of those drug tests. So despite the legislature here in New Jersey passed this law, which I'm a huge proponent of, I work in the licensing space, and I'm happy to see the CRC here. This has been an ongoing problem where we've seen an uptick in positivity rates, and we have no data on the other issue. The CRC, I've always looked at them as a licensing entity, an entity that's supposed to set up the framework for a healthy adult use marketplace and a safe marketplace for patients. This is a component of what they do, but that's not their primary reason for being. The labor aspects of this might be a novel idea, but the Department of Labor would be a definite player I'd like to see involved in these discussions going forward. It's not to say that they won't be, but it's just something that I say to myself as an attorney, as a policy person. It would make a whole lot of sense to see them involved in these discussions as the situation evolves, just because it would give the business community, it would give a lot of the public interests that are involved in this a bit more of an assurance as to what's going on. Because despite the CRC knows cannabis up, down, left, right, there's an entire different regulatory agency out there that is specifically geared towards labor issues, which I'm guessing the CRC, with everything else that they have going on right now, with the Herculean effort of getting this new marketplace off the ground, they could probably use that degree of expertise too, which may or may not happen in the future. We'll see. I'm optimistic as always as we move forward with these types of things.
Thanks, Bo. Jeff?
Good afternoon, everyone. My name is Jeff Catalano from the law firm of Parker McKay. I work in the Labor and Employment Department. I also work in the School Law Department. I'd like to thank the NJBIA for having us today, and we're happy to be able to provide a forum to have such an important topic, especially one so timely. I'd also like to thank Bo. He's taking some time away from his newborn, so I want to thank him for taking some time this Friday to also provide his expertise. I've learned a ton about cannabis just from talking to Bo. But I'm here to provide you the labor perspective. I deal with labor and employment issues, policies for your employers. I deal with collective bargaining issues across the board. And I know a lot of people are here, employers, HR professionals, wanting to know, do you have clear guidance for us? Do you have some advice on where we go from here? And to borrow a very bad cannabis pun, unfortunately, things are still pretty hazy here. You're talking about a scientific scenario that we haven't gotten to the point where we have impairment devices that can determine in-time impairment. You have reasonable suspicion observations reports, and we'll probably get into the State v. Oleniewski case and the 400-page special master report that I read so you don't have to. But the key there is you're talking about drug testing. And you're talking about what credibility analysis might enter into your employment scenario. You're talking about what type of weights and validity you have to do, how many different steps in terms of reasonable suspicion and observation is enough to count that as impairment in the workplace. And you have to give credit to the CRC taking such a Herculean task on when there have been many states across the country who have had legalized cannabis for longer than New Jersey and still have not promulgated the guidance or guidelines when it comes to workplace impairment. We're here to try and offer some clarity, here to offer some amount of guidance through these murky waters, but ultimately, when you're talking about workplace impairment and you're talking about drug testing, this might ultimately come down to how risk averse you are. And there is a colorable argument right now in terms of risk aversion to not test for cannabis at all. There is a very colorable argument that might even open up some labor opportunities for you to hire different segments of the populace if you do not test for cannabis. But I'm sure we will get into that today. And I hope we can provide some guidance here.
So, Jeff, let's get into it then. Let's get in. So we have 120 some odd people on this call today. They're probably all from HR departments. They're all trying to figure out, now what do I do? They've had a year and a half with CREMA out there, waiting for wire regulations, trying to figure out what to do in the interim. Well, there are no wire regulations at the moment, but we have guidance. So I'm an HR professional. I come to you for labor advice. What do I need to do? Do I need a drug testing policy? Does it differ from cannabis to everything else? How do I protect myself as an employer? And more importantly, how do I protect my employees and the community from an impaired employer?
Well, number one, I think you hit it right on the head. Every employer needs a drug and alcohol policy, and it needs to be specifically tailored to cannabis. Cannabis is different than alcohol. Alcohol, we have breathalyzer tests, tests that you can immediately determine whether someone's BAC is of a certain level. For cannabis, you can't. There could be the same level of THC in your blood system if an employee smokes up right before their shift, or if they attended a party over the weekend where other people indulged and they didn't. It is possible that the same levels could be there. So you have to kind of take everything with a grain of salt when it comes to cannabis. And where the CRC's guidance does provide some clarity here is having employers designate a staff member or a third-party contractor to assist when you're talking about suspected cannabis use. The issue comes here in the practicality when it comes to dealing with the interim staff member. The guidance states that staff member should be sufficiently trained to determine impairment. Well, I just told you that there is no impairment device that can tell you in-time impairment. And it's unfortunate that there isn't one, and the science hasn't caught up to that fact, but that's just where we are. And Bo can probably talk a little bit better about the actual tests themselves. There's some promise in ocular scans. There's some promise when you're talking about certain other tests. I believe there's actually some sort of video game that can actually test impairment in time on how you're handling your duties. But until we get some sort of scientific based way to determine impairment, we're kind of a little bit on uncertain ground here. So you look at the training. What training can I do? How can I determine somebody's qualifications? Well, fortunately, the special master in the State v. Olenuski case actually provided some guidance here.
Just for the crowd, can you explain what that case is and why it's relevant?
Certainly. So in that case, this is a case up at the New Jersey Supreme Court right now. State v. Olenuski is determining whether drug recognition experts, the police drug recognition experts, whether that testimony is reliable and admissible as evidence of intoxication. And while this special master report is not a legal decision, and parties still have briefs to file and parties still have arguments to put in front of the Supreme Court, what the special master stated is that the DRE program replicates generally accepted medical practices in identifying the presence of impairing drugs and the likely category of those drugs in an individual exhibiting indicia of impairment. So if you take a look at the DRE process, there are 12 steps, and this is the DRE process that is used by police officers. There are some issues with using that process. For instance, a lot of the individual 12 steps were determined to be reliable, subject to the credibility and weight assessment by a fact finder, which means there's wiggle room here. You can actually an attorney can challenge your credibility when it comes to this evaluation. Moreover, the expert witnesses dealing with DREs universally agreed that the evaluator, whether in a medical context or a DRE, would never form an opinion that would be accepted as reliable based upon any one or even a few isolated factors. All of the observations have to be taken in consideration and assessed together. So what it seems to me from the special master's report is that employers that just want to say, okay, DRE, let's just do the 12 steps. Well, not all those 12 steps work for you. A blood alcohol test doesn't tell you anything about cannabis. So you need to have these factors formed together as a scientific method. And in order to do that, you need to find some sort of training when it comes to what are the typical signs of impairment for cannabis. And honestly, that's easier said than done. One of the typical signs of someone under the influence of cannabis is a bloodshot eye. Well, is that person under the influence of cannabis, or are they having an allergic reaction that day, a reaction to hay fever? Another instance could be tiredness or lack of attention, or kind of like droopy eyes. Is it cannabis, or did your puppy wake you up at 4 a.m. in the morning and you just didn't get a good night's sleep? All of these are going to be fact-intensive analysis. And the best advice I have for you, and unfortunately it's kind of a cop-out answer, is you have to talk to your labor lawyers. You have to get people involved, because until we get some cases, until we determine some sort of what is enough for a reasonable suspicion, it's going to be case by case basis. And you're going to have to not only have a drug and alcohol policy, but administrate it in good faith and consistently across all of your employees.
And what I'm hearing from, labor attorneys, you, Bo, and others, is everyone is trying to avoid that risk. Everyone was hoping that the CRC would give them, here's exactly what you need to do. Here are the factors. Here's the standards. Here, let's fill in all those blanks, because without all those blanks being filled in, then the defense bar, has wiggle room to challenge any determination you made. But Bo, let me turn to you for a second, for you to add in here. But also, the world of impairment didn't begin with the adoption of CREMA. People have been using cannabis and other drugs for quite some time. Medical marijuana has been around, for a while. But the issues of impairment are not new. So what advice would you be giving your clients?
Well, big step back again for just a minute. And I can't echo Jeff on something with a big exclamation point, jumping up and down, lighting myself on fire enough. You need a drug and alcohol policy. And I'm not just saying that because I'm an attorney, it's because it gives you special protections. We have, and the legislature, with some forethought, gave some redundancy to the law here. They were trying to do something pretty cutting edge with the wire aspect. This is the perfect intersection of all branches of government. The executive with the CRC here, the courts with Olenowski, and the legislature putting this law together. And where we're currently at is we're at that point of needing that redundant aspect of the law. And the only thing that's really going to protect a business is a solid drug and alcohol policy. Because in my opening statements, I alluded to it, but everybody should, after this is all said and done, look up what Delta 8 is, look up what Delta 10 is. It's all these darn isolates. You've all probably heard of what CBD is. These things will all trigger a positive drug test. If you have a malicious employee that wants to come after you for saying you got fired from one of these, it could raise all sorts of issues. There's a whole host of issues right now when it comes to identifying what the substance actually was that a person took, because our drug testing just isn't that sophisticated. It more or less looks for fallout in your system. It's not like, oh, it's Delta 9 THC and it comes from the cannabis indica, cannabis sativa, or that's hemp derived. It's positive, negative. You have metabolites in your system. That's it. So we've never had more ways before as a country to fail a drug test. And meanwhile, one of these, one of this category of substances, the hemp derived ones, they're already legal and they'll call as a failed drug test. And that's being woven into a lot of different products. If you're ever driving around and see that at a gas station, if you're ever seeing that one of those little pop-up hemp stores or whatever it is, completely unregulated. It's a bit of a federal snafu from the 2018 Farm Bill. But here in New Jersey, with what we did with our law, trying to do something cutting edge, we've given cannabis consumers certain protections, cannabis patients, importantly, very justifiable protections, with certain exceptions like safety sensitive positions. I'm trying to phrase this right. There's a new way of how to engage with your employees that your HR manager really needs to understand the nuances of. Your policies, number one, should probably be updated if you have one. If you don't have one, get one. You need to know the nuances of how to engage with a prospective employee. And even if you have a drug and alcohol policy that might be a little bit liberal towards cannabis and you have a positive drug test, you need to know how to engage with your employees and give them the opportunity to explain what's going on. Are you a medical patient? Did you just completely say, screw it, I'm going to throw the policy out the window and do what I want? You know, I've had situations where I've been approached by some public sector entities that have said, hey, listen, this was prior to the first sales of the adult use cannabis having happened. I'm like, the entity said, we've had a prospective employee who we really want, and they failed their drug test, and it's clearly illegal what they were doing. And I said, how do you know it didn't happen in a state that's already had adult use sales? How do you know what substance they took? How do you know that they're not a patient? And it was completely all these, lost on the individual, but there's ramifications for engaging the wrong way. There's potential fines that could be levied by the Department of Labor. So these are things that you need to be cognizant of. Now, it's not the end of the world here. It's a little intimidating as things change. But again, that exclamation point of have a drug and alcohol policy, get one. It's really that simple.
There are a number of questions in the chat. So I want to backtrack because we had a basic question that was, someone said they missed the first 5 minutes. What is a wire? So let me just quickly say that a wire under the CREMA, which is the legalization recreational adult use law, is a workplace recognition expert who the law says should be used to do a physical examination before you can do a drug test in order to protect or to take a disciplinary action against an employee who is suspected of being impaired. The CRC is supposed to come up with regulations. We talked about that they haven't been done yet, but they're being worked on. So, Chris, let me bring you back in. Can you give us any indication where the CRC is in this process? Are you waiting for the State Police Training Commission? What do we need to know? And you're on mute. Now you're good.
I got you. So we're just in the process of stakeholdering, right? We've been talking, obviously with you, Ray, and the folks at NJBIA. We're talking with, other states that are experiencing similar problems that Jeff indicated, that this is a difficult area to regulate around. We need to develop a curriculum that's sound and something that's, every business has the ability to, designate that person to take the courses that we develop in regulation to be certified as a wire. But, as you stated, I can't really give you a timeline. We hope to have that happen soon, but we are working behind the scenes to do the research so that we get this right when we do develop the regulations.
There have been a number of questions. We've been all using the term safety sensitive position, although that term does not appear in the law. So there is no breakout for safety sensitive positions. The same rules will apply to a Walmart for their cashier as will apply to someone operating in a chemical plant or operating a crane. So there is no distinction. But the law does make a distinction if you have other requirements under federal contracts, not necessarily under federal law. So, Jeff, can you address what you can do under, if you're required under two things? I'll give you two scenarios. You have a federal contract that requires drug testing, but now, CREMA says, or the main provision of CREMA says you can't do that, or rely on that alone. And then what happens if you have a law such as for CDCs under federal law that says you must do drug testing there as well, but it's not part of a federal contract? Can you explain how that works together?
Well, certainly. Fortunately, the CRC does provide some clarity regarding federal contracts. In the interim guidance, it states that if it's determined that any of the provisions set forth in the law result in a provable adverse impact on an employer subject to the requirements of a federal contract, then that employer may revise their employee prohibitions to be consistent with federal law, rules, and regulations. So if you have a federal contract and that federal contract requires you to test for cannabis and fire for a failed drug test, according to the guidance, it appears that you're able to do that as long as you have a provable adverse impact. Now, if you're talking about not having a contract without a federal contractor status, this is also kind of a gray area when it comes to safety sensitive positions. And I don't want to give a general definition of safety sensitive because it's kind of an amalgamation and it's still being worked on across many states. A lot of different governments have a different sense as to what safety sensitive is. But in general, it means that a position involves some aspect of a heightened danger that requires an employee's full and unimpaired skills and judgment to safely execute his or her job. The issue comes with safety sensitive positions, and as Ray stated, there is no mention of safety sensitive in the New Jersey law. Other states do have safety sensitive exceptions, and I represent many police departments, many firefighters, where there isn't a safety sensitive exception for them. Currently, they are still protected from an adverse action if it's based solely on the result of a positive drug test. And I believe there was an attorney general letter, an advice memo, something along those lines as well, saying that police officers had the right to use recreational cannabis. I just can't recall the specifics off my head. But ultimately, there is not an exception. I know there were a couple legislative bills that tried to do safety sensitive positions. I'm not sure where they stand in the legislature right now.
They have not passed. One, I forget the bill number, Senator Sarlo, who was a champion of providing for additional protections, put forth legislation. But the Senate President, the current Senate President Scutari, who was the then just a plain senator, but author of CREMA, is adamant that he believes what he put in the bill for wires and its testing protocols are sufficient. So those safety sensitive exclusions that the Sarlo bill would have allowed were not passed, and we have no expectations that it will be passed.
Right, and I can talk about one specific example. I had a client contact me about their drug and alcohol policy saying, I don't want someone who's driving a 50-ton fire truck to be under the influence of cannabis as they drive the fire truck down the road. They don't want to have that risk, not only for their insurance purposes, but a risk for anyone in the public and dangerous. So they asked me what we could do about it. And I said, well, there is no exception for firefighters. You have to follow the law as possible. So one of the things that I suggested, in this, particularly this unionized workforce, was something called impact bargaining. Whereas you have a managerial prerogative in a unionized workforce to make a drug and alcohol policy, to enforce that drug and alcohol policy. And when it comes to the public negotiations, there is no right for the union to come in and say, I want to negotiate about those terms. But what you can do if you're an employer is negotiate with that union about the effects of your decision, the impact of your decision. So this particular client brought everyone in, had a huge town hall meeting with all the employees, and had an open conversation about, here's what we want to do with our drug policy. We know you don't get a chance to negotiate about what we actually put in there, but we want to hear your opinions. We want to hear what matters to you. And by doing that, you're able to buy some buy-in on this policy. And that might also be an interim way, especially in a unionized workforce, to kind of get through this until the science catches up to the law.
Well, we just had a question that came through. It's a company that has a drug-free policy. Wires aren't out there, but they're worried about their hiring practices. What can they do? As far as hiring is concerned, can they drug test before they hire someone? Can they decide not to hire someone based on a positive drug test?
So it's funny. I was actually talking to Chris about this there and Jeff about this the other day. When you're in law school, they teach you this very obnoxious way to introduce evidence in a courtroom, and it's almost like a dance. You have to, go here in the courtroom, go there in the courtroom, show to opposing counsel, ask that if the witness needs to have their memory refreshed, and so on and so forth. And to a degree, this is a lot like that dance, or it reminds me a lot of it. And the rules have slightly changed just a bit. Right now, the first thing, if you have a drug and alcohol policy already, the very first thing you should do for a prospective employee is give it to them. Let them know it exists. You are still allowed to do pre-employment drug screening, but you, just as a CYA, want to make sure that anybody you're having a discussion with about hiring, that you let them know that you have this policy in place. Also, too, and this drives me nuts whenever I see it, some drug policies, drug and alcohol policies, touch on the specifics like marijuana or THC. Again, just want to really jump up and down and say this with a big exclamation point. Drug tests don't deal with that. They deal with cannabinoid metabolites. It's a drug test positivity. That's what your policy should really be discussing, because there's nothing nuanced enough to actually detect that.
Yeah, and just to clarify, you could drug test someone before in the employment process or the hiring process, but you can't not hire them based on a failed drug test for cannabis.
Correct. Unless you have a policy in place.
It was mentioned before by Jeff. You had talked about firefighters. I think you mentioned police officers as well. The Attorney General's opinion. I believe that at least one municipality said, we don't care what the Attorney General said. Our police officers are going to be banned from using cannabis. Chris, is that something that the commission gets involved with, or that's going to be an individual enforcement issue, town by town or business by business? Everyone knows the law, but you guys, you're not going to send letters out to towns and saying, no, you can't do that.
No, we're certainly not going to get involved in that type of situation. We're not going to send letters out. As the statute requires, we're going to develop a curriculum to certify wires, and then all that determination is going to be up to the employer. Jeff and Bo will, in the private sector, are the folks that will advise these employers of how to handle those types of situations. We certainly wouldn't get involved in any of that. What we know is what the law says is that, you can't rely on a drug test alone to take an adverse employment action. And that's how our guidance is directed towards all these employers and employees of those types of situations.
And again, we keep getting a number of questions about safety sensitive positions. I'll reiterate that the law doesn't make a distinction for safety sensitive positions. However, I'm sure everyone would advise that if you are dealing with a crane operator or someone, police officer, someone who's driving a truck on the roads, that it's even more imperative that you have a good workplace impairment policy, drug and alcohol policy in place, and that you have you follow the guidance or have your own expert guidance to make sure that you are maintaining a safe workplace. Jeff and Bo, do you want to ask Chris or each other any questions, or go ahead, Bo?
Just something else that the guidance talks about that I'm thrilled to see that the CRC is looking at, and we've all had discussions among ourselves as to what this could look like. The evaluation of an individual, even by someone who's well trained, is still somewhat subjective. So I'm happy to see that the CRC is looking at some device guidance here and device usage, but we're talking about device usage in a civil context. And if there's any legislative staff on this or front office staff on this, I would jump up and down and say we probably want to put some guardrails on that. Devices in the policing space, these things mostly have FDA approval. Devices for I shouldn't even say for cannabis, it's impairment devices, ocular devices, game theory devices. These are things that are still pretty cutting edge. The R&D on it's relatively new. Hasn't gone through the same level of scrutiny as medical devices have. What makes a good device versus a bad device? Is a device that a company need to be registered with the state? Is a device manufacturer going to have to say, I'm selling one of these devices in my state? God forbid there's something about this device that comes out that says, hey, one of these ocular devices discriminates against a segment of the population. We'd want to make sure that device is no longer being used right away. What's the raw data on the device? Is that information being shared with the state? Is there any type of study as far as to the amount of people who aren't able to work? Because ocular devices, it's basically how quickly are your pupils moving? Some of these game devices, it has some data as far as on your phone as to your normal touch usage. Tap the dot on the screen as fast as you can. It's not testing for cannabis. It's testing your reflexes. It's testing your eye movement. Very promising space, definitely the future of impairment testing, but you'd want to see some guardrails on that. Either way, though, very exciting, very happy to see that the CRC is looking at that as the future, because it really is.
And both what I'm hearing from you and Jeff as well is that drug testing, alone, especially given all the limitations of testing and the possibilities that you could be determined positive without having taken, without being impaired or having taken cannabis even, is not the end all or be all, of a drug testing policy. That you really do need to have a much more sophisticated policy that looks at impairment, that has the right guardrails in place, the right responses in place. Maybe part of the answer is have really well-trained HR professionals, good policies in place, talk to your labor, attorneys, not to give plugs to our panelists here, but you should not be winging this and assuming that, you've been around long enough to know who's high and who's not, and should not be running your business in that fashion. I wish we could do a doodle poll, of folks here. I'd be interested to know how many folks on this Zoom today have a drug and alcohol policy in place, and how many have updated it since CREMA was enacted into law. There's a question: are there any exceptions for healthcare employers or settings? Who's testing your surgeon to make sure that he's not impaired? Jeff, you were shaking your head.
Yeah, there is no legislative act there. However, certain professionals are covered by different rules of professional conduct. I actually read a very good article questioning whether lawyers using cannabis was a violation of the rule of professional conduct, going back and forth. And I saw it was a fun article to kind of just look into it. But for medical doctors, I believe there is a rule of professional conduct regarding cannabis use doing surgery while impaired, but don't quote me on that.
And that's while impaired, because this stays in your system for a long time. This is not somebody who is necessarily impaired, but it goes back to, particularly in the healthcare space, it gets really tricky because You have different practice groups that are subcontracted by hospitals and everything like that. What did the contract read? Is this a unionized entity? How's the collective bargaining agreement read? I mean, this gets very, very messy very quickly, but there's really no perfect answer. But we're trying to, as a state, come up with a better way of just saying absolutely no way in hell. We still keep that option on the table with a strict drug and alcohol policy. The legislature, again, kept that in place. You still can completely insulate yourself as a business from one of those, but you have some flexibility here to how you can view this.
And to answer one of the questions along these same lines, I see someone asking about whether there's a list of tests that meet the cognitive impairment test, the scientifically valid, objective, consistently repeatable, standardized, automated test of employees' impairment. I would love to be able to give you a list of these tests that meet that requirement. I'm not certain the science is there to determine in-time impairment. As Bo is saying, the science is getting there. They're working on the ocular scans. They're working on the impairment game theory devices, but I don't know if I can recommend any certain test until we get some sort of regulation or some sort of approval by either the DOL or by the FDA.
And at the moment, the CRC is not going to be making any recommendations or giving us a list of approved tests. Correct, Chris? You can just shake your head that you're not going to do it.
No, we won't be given a list of approved. I mean, as the guidance states, we're allowing that as an option. You may use those types of things to develop your evidence of reasonable suspicion, right? Your physical science. You just kind of stack all that evidence up to get to your reasonable suspicion standard prior to subjecting somebody to a drug test and then taking adverse employment action.
Yeah, I'm not making a pitch for it, but we've been talking about those acuity tests, those game tests. For those of you who were attended our last seminar on workplace impairment, we did have a gentleman, I think it was from Triple S Steel, who does use one of those, and he spoke fairly eloquently and favorably about that. But again, if you haven't heard that seminar, you could probably sign up for it late, and get a copy of it and listen to him if you're interested in hearing what he had to say. There's a specific question about CDLs, and I know it's important because under the CDL law, and actually there are a number of other federal requirements similar to this as well, where you cannot operate a truck on the road with a CDL license while impaired, and I believe it has drug testing as a requirement in order to make that determination. Although under CREMA, you can take an adverse action if you're volatile. So how does it work out? I have a CDL license. I have a fleet of trucks. My drivers all have CDL licenses. What do I do?
Don't touch
Jeff
it.
or Bo, go ahead. Anyone.
The shorter answer is if you have a CDL, don't touch it. That's a federal license. It's a safety sensitive position. Do not touch cannabis. Don't touch cannabis isolates. Don't touch CBD. You will be fired.
Yeah, especially a lot of things that have federal tangent. Because remember, cannabis is still a controlled substance federally. So we've been dealing with the firefighter's death benefit. It's a federal death benefit if you die in the line of duty. And my advice, until you get some guidance from the federal government otherwise, if you get a positive test for cannabis during that autopsy, you can probably kiss that benefit goodbye. So it's one of those things where you really have, especially if the feds are involved, you really have to play it safe if you're the employee and the employer.
So you guys,
Janet's question, real quick. It says it was say that an individual cannot be denied employment based solely on a positive test. So just to elucidate a little bit here. So we have given protections to cannabis users, to cannabis patients. And the idea behind this was to make sure that no one is being discriminated against. Now, absent a drug employment policy, If somebody is just a cannabis user and they have failed their pre-employment drug screening test, you can't say, you're a cannabis user. I'm not hiring you just because I don't want like cannabis people and they're all crunchy and they went to too many fish shows and the debt is the reason for being. That's discriminatory. You're going to get in trouble for that. If you have a drug and alcohol policy and you make that clear to the prospective employee that this is a cannabis-free workplace, or that you've maybe got a 3-strike policy, or you put up some guardrails and you can build that in, that's a different story as to how you want to engage with them. But it's giving yourself that type of rules for the space. Now, lighting myself on fire about this, we're talking about cannabinoid metabolites as far as a drug test goes. It's not just legal weed. It goes beyond that. You can get Delta 10 from orange peels now. That's psychoactive. It will get you high. So you mean we have, despite the feds are a little bit asleep at the wheel right now, not a little bit, the feds are asleep at the wheel on many fronts. But when it comes to how drug testing occurs, how the interstate commerce of hemp has evolved, what states are doing with adult use and medical marijuana marketplaces, it gets real messy real fast. So what I would love the state to do is come up with a model drug and alcohol policy for the little guy that might not want to afford an attorney or to pay for an attorney.
You two have raised or opened maybe a can of worms by talking about the fact that cannabis is still a regulated substance on the federal level. And that raises a whole host of other issues that we really haven't explored. I know it gets, Chris is dealing with it all the time, when we're dealing with standing up a marketplace that may not be able to use federal banks, for credit, et cetera. But what complications does the fact that it's illegal at the federal level, how does that apply into our drug and alcohol policies here in the state and what people should or should not be doing? Or should we just go to our local cannabis store and not really worry about it at all? Go ahead. Go ahead, Bob.
Can you repeat that real quick? You broke up for a second.
I'm sorry. Again, I was just wondering, given the fact that cannabis is illegal on the federal level, what additional complications does that raise for our state policies and for employees, who may be using cannabis?
It's an absolute mess. I mean, the federal level treats cannabis as a Schedule I drug. It's the same as heroin as far as the feds are concerned. Clearly, if anyone ever went to high school and enjoyed themselves, so that's actually a terrible example just because you shouldn't be doing that in high school. If you went to college and you might have partook, you would know that this is not the devil's lettuce. This is, something that, given the proper safety guardrails, given the proper oversight, can be a safe marketplace. Now, since it's federally legal, though, anything that touches on federal contracting, anything that touches on your job that might go into another state that might be relevant there as to your job, you got to be careful about this. And going back to my point, there's never been more ways to fail a drug test than there is right now. How does your company do business is really a question that you have to have in the back of your head at all times. What is the nature of your employees' responsibilities? You really need to have that conversation with your HR manager. You really need to have that conversation with your attorney. Some of this is not complicated. Your employees, a lot of them are already imbibing. This is not anything new. What is somewhat unique about New Jersey is most states have very much a caveat emptor approach when it comes to cannabis usage or a failed drug test. You're up shit without a paddle. New Jersey, we have given certain protections in place for the employee. It's commendable. We have not also left the employer completely defenseless, because we have that other side of the sword, which is rock solid, have a drug and alcohol policy.
We've been focusing primarily on CREMA and adult recreational use marijuana, but cannabis has been legal in New Jersey in the medical context for a number of years. Is there any distinction from an employer perspective, workplace safety between medical cannabis and recreational cannabis?
I mean, in terms of the labor law, you probably have to worry about some interaction with the ADA and the NJLAD. But in terms of, actual cannabis, no, both laws state that you cannot fire someone for a positive test alone. So.
And, absent a drug and alcohol policy, if you had a positive drug test for an employee, that might have even been demonstrating an observable sign of intoxication. You do have to get, and you drug test the employee and they come back with a positive drug test. You do have to give that employee the opportunity to say, I have a medical marijuana card. Yeah, give them that under Jay Koenig's law, the law that really expanded our medical marijuana law that was anemic since 2010. You have to give that employee the opportunity to explain themselves before you can do anything as far as adverse action. Because if they do have a medical marijuana card, they're protected absent a drug and alcohol policy.
Yeah. And that actually goes back to a question that was earlier in the chat regarding a rule of thumb regarding impairment. How long can a person use cannabis prior to their shift? And I would, again, love to provide that answer for you. Unfortunately, the way cannabis is derived and the way cannabis is ingested by the body, it affects people differently. And there are different time frames, different things. It could affect people differently. And it's unfortunately not something where there's a clear cut, like alcohol. You can probably put a line in the sand basically saying, hey, 8 hours before your shift, don't use. You could probably even make that a little shorter before your shift. But at the end of the day, it's about cannabis being just different than alcohol when it comes to that and how you test it.
And again, I'd really like to say to the CRC, got guts for being here, because this is a really heavy discussion to be had. I'm so curious as to how will the Department of Labor fall exactly in line with your interpretation of the law? Could they have a different interpretation of the law than what you have? The form that the CRC put out for a reasonable suspicion observation reporting form, how was that developed? Who were the experts involved? Can I help you out here, Chris?
Sure. So, we obviously looked at the law and developed this guidance because that's our interpretation of the law, right? And again, we're talking about reasonable suspicion of impairment, right? It's not just...
It's only in the civil context, not the criminal.
Correct. And it's impairment. The key is impairment and not just use, right? People have the right to use cannabis. Actually, it's a constitutional right because we passed, the ballot question passed, and we have a constitutional right to use cannabis when we're not working. And when we're not at the workplace. You can't be impaired at work. The form was developed through consultation with, various attorneys, labor and employment attorneys. I'm a regulator attorney. I help write the regulations. So we talked to the experts, and this is kind of what was being used by employers out in the field, right? They're using these reasonable suspicion of observed behavior reports. They're designating a staff member to document physical signs in the managerial context or human resource context to look at these observable physical signs, document these signs, and then that might be a grounds to trigger a drug test, and then you can rely on that drug test when you stack up all those signs as well and you document them. Both of those together might be enough to take adverse employment action.
Yeah, and Chris, the form that as part of your guidance that you put out, it's not mandatory. Employers can talk to their attorneys, and they could put together their own forms as they think best for their own purposes.
Absolutely right. They can put together their own form if they're already utilizing some type of form to look at for reasonable suspicion of observed impairment behaviors. They can continue to use that form. but you're not required to use this form. We felt that it was necessary to kind of give some kind of sample type form so that people could understand the guidance and what we're actually looking for as documentation of physical signs of impairment.
Give you a report.
We actually have a hand up.
Yep. Hi.
Rachel?
Yes. Can you hear me?
Yes, we can.
Okay. So the question I have is the agency that licensed us, we run a day habilitation program. They randomly will give us a name to do a random drug test on. So why is this still being tested for if it's, I mean, obviously we understand the whole aspect of there has to be some type of impairment that we see. So we understand that, but why is it still part of the random drug test that the state requires if it's not something that we could use in isolation, so to speak?
Chris, do you want to answer why your fellow agencies are still testing for cannabis?
Unfortunately, I can't really speak to that. But you know, there are agencies within state government that have federal dollars connected to them, right? They run the Medicaid program, the Medicare program, things like that. That's federal dollars, matching funds, things like that. And the law clearly has that federal carve out. So I'm not certain of what agency you're talking to, but I imagine there is some kind of federal component there and federal carve out that they're relying on.
Do you work at higher ed, anything that receives federal dollars?
It's through DDD. So it's a day program and they still have that as part of their requirement. So yes, there is the Medicaid funding, billing for that. But when this came up in the past, the guidance we got was, well, we will not, we will not come after you for not taking action, but we will come after you for, not taking action if someone is impaired. Like it was kind of like one of those things where, it's just CYA. And obviously if we see somebody that seems impaired while working, we're of course going to send them for a test ourselves. But I just feel like what's the point in doing the random test and including that component to test for if there's no visible signs of impairment, and then we get this test that shows us, okay, maybe someone is positive, but there's no visual signs. I mean, we haven't seen anything to show impairment at the workplace. So then what do I do with this?
Yeah, and I'll let, again, if Jeff and Bo want to jump back in, but the drug test that's being required, I assume, is for other drugs as well. So it's not just cannabis. So, it may have efficacy in picking up other things that are clearly illegal and will show impairment at that point in time. It may show cannabis, but, the question is, it may not show that they're impaired at that point in time. And again, we've been talking all day of the conflicts between federal laws and policies and drug testing policies that are out there and what CREMA provides and it allows and doesn't allow. Jeff, did you want to, jump in or add or?
Certainly, I can jump in and add on that. I mean, if you read the law alone, and this is probably not going to be the most satisfying answer, Rachel, I admit that for a second, but when it comes to these random drug tests, as the law reads, unless you have something else in addition to that positive test, you can't take adverse employment action. Unless you have some indicia of impairment or there was a workplace accident, unless there was something else, something plus this positive test, you can't really take any adverse employment action. As to why they still include that in the random test, you're probably going to have to follow up with the agency themselves.
And always keep, it would need a deeper analysis, and I don't want this to be construed as legal advice, but I mean, there does run a risk here of this is federal dollars. What's the agreement with the Fed? Because this cuts the other way. You might not be able to take an adverse employment action against the person, but could this impact your funding? So this is always something that, becomes very messy very quick. Now, I've said since 2018, 2019, when this first started becoming a real issue, we are in this weird Wild West when it comes to cannabinoid metabolites because the Feds made a boo-boo in the 2018 Farm Bill. How do you know what the heck the person tested positive for or what they consumed? One of these substances is quasi-legal just because it's a gray area under the law. The other one's federally illegal still as far as a plant goes, but it doesn't specify in the drug test that you're taking one or the other.
Yeah, and again, a lot of this obviously is complicated, but to Rachel's question, is it possible taking Medicare and Medicaid dollars and those requirements are a contract under CREMA and therefore, under that exception for drug testing?
Again, that would probably have to require some deeper analysis, not suited to a presentation like this.
In other words, Rachel, you should contact your labor law attorney and get a much better analysis of that.
Yes.
Maybe we should be doing one of these seminars specifically on the healthcare industry. There seems to be an awful lot of questions that have been coming about in the last year or so, specifically from that industry. Not that everyone else doesn't have issues as well. Any more questions? By the way, anyone can just raise their hands and I will call on you. Let's see. I'm just looking back at the chat. So this one's for Chris. It's kind of open-ended. I'll read the whole question. In addition to publishing wire certification standards, what are CRC's other current priorities? Don't spend all day on that. What other types of CRC guidance should employers expect in the future? In other words, are there specific elements of the current guidance CRC expects to flesh out? So what are you guys working on, Chris? And what else can employers expect coming down the road? And we only have a few more minutes for this question.
Sure. I'll be as brief as I can, right? We're working on a lot of things. We're the licensing agency. We're the licensing regulatory body. We're working to get entities licensed, and we stand on the two pillars of safety and equity. We want an equitable cannabis market, but we also want a safe cannabis market. So that we're working on regulations. We're obviously prioritizing patient access points, and patients. The patient regulations, the medicinal marijuana regulations need to be rewritten. We're working on that behind the scenes in my office. As far as the guidance goes, really, it's going to be up to the employer to take the guidance and run with it. And like I said, we're looking for reasonable suspicion of impairment. The guidance document is as clear as we can make it. It's our interpretation of the law. We're just clarifying and explaining what we understand the CREAM Act to mean. And what we believe it means is that, you cannot rely on a drug test alone to take adverse employment action. You need to have this, you need to get to this reasonable suspicion standard. How you get there, that's going to be up to the employer and really up to, everybody out here and Bo and Jeff to figure out, how do we get to that reasonable suspicion standard to ultimately take adverse employment action.
Someone asked if does anyone have a model drug and alcohol policy they could recommend? I'll just throw out quickly. I'm sure every attorney has ones that they usually probably use. It's probably modified for each of their clients based on their specific needs. I know, NJBIA has a HR service, and within that service, there's a drug and alcohol policy as well. But, are there any best practices, or should they just call you guys, talk to their attorneys, talk to their HR professionals, and make sure they develop their policy? And by the way, I'm assuming that everyone should have an updated policy as well. If you have a policy that's 5 years old, you don't have a policy.
I'd be glad to provide some advices, however you want to update your policies. If you want to update them or have a new one, just stay up to date, because this is going to be an evolving aspect of the law, not only here in New Jersey, but across the country. Who knows, we might get some federal guidance changes. There may be some things in the future that may come out, but you constantly want to be up on this, not only with the state law impact, but how things change across the state. And there may be cases that happen in other states where cannabis is legal that may affect or may provide some sort of cues as to how an employer should best handle their policy or how they should best deal with drug testing. So all of that is going to be in flux, constant state of flux. I know everyone wants that straight answer. I want it too. If I had the straight answer, it'd be a great day. But we're going to have to wade through this fog together and kind of find the stable ground that way.
The only bright line we have, literally, the only bright line we have is you're insulated if you have a drug and alcohol policy.
Yeah.
I wish it was a lot simpler. I wish I didn't have to say, go to your attorney, get it cleaned up. It's something the legislature left in place. Good. I'm happy they did because we need to protect our business community. We love our business community, but we also need to respect what an employee's rights are and recognize too. Also, keep in mind, just because you have a drug and alcohol policy and someone has a positive drug test for cannabinoid metabolites, doesn't necessarily mean you have to fire them or you have to not hire them. Depending on what that policy says, it might flat out be a bad idea depending on the nature of the job, if it's a safety sensitive position, if there's federal contracts involved or whatever. That's something that needs to also be considered here too, because so many employers are afraid of, okay, if I give this to a prospective employee, it's going to scare them away. And we have a real workforce crisis right now.
Yeah.
Well, there's ways of having that conversation and recognizing that, like, you don't necessarily need to lose talent. There's still a way you can insulate yourself from a potentially other employee who may be malicious.
And again, not only have a drug and alcohol policy, but you got to administrate that policy in good faith, and you have to administrate it consistently. You don't want to, have this policy and somehow do it adversely to a protected class or anything like that. You have to be consistent across the board.
I'm going to drop into the chat real quick the test case and the docket number for everybody that's interested in following that. This was what was filed recently in South Jersey against Walmart. It's a class action. It touches on all of this. Going to be really interesting to see how this plays out.
Just really quick, I know in the chat as well is a link to NJBIA's HR support tool. There is a policy as part of that as well, so you may want to check that out and see if that is helpful for you. Danielle, Danielle is running this whole thing behind the scenes. You had your hand up, Danielle?
That might have been a mistake.
Oh, in that case, we will ignore the fact that you have your hand up. Let me try to ask one complicated question. So a lot of us are now working remotely, and we may be working in other states. I may be a New Jersey employee, but I'm working for a company in Pennsylvania or vice versa. How do these restrictions on impairment testing apply when we have employees and employers who aren't even in the same state? Can my Pennsylvania company drug test me? Can I test my Pennsylvania, or am I limited in testing my Pennsylvania employee? Speculate, guys. How does this play out? But it's more and more of an issue because we're all working remotely.
Let's start with the first question where we're talking about remote work. If you work for a New Jersey employer and you remote work in New Jersey and you test positive for cannabis, that's going to be a harder argument to make before a judge that you're affecting the drug-free workplace. Remember, employers, you have a right to a drug-free workplace, and you have a right to a workplace without anyone under the influence of cannabis. So it's going to be a harder argument to make unless there is somebody on a Zoom clearly, using cannabis while talking to clients. It definitely is going to be interesting. It would be an interesting test case.
You'd want to make sure you get a New Jersey venue for number one. I just like the thought of, and it happens in the drug testing's place where some company is so angry that they might even suspect somebody of using cannabis, and it's not a safety sensitive position, or it's not something tied to federal contracting. They're still trying to make sure that their employees, who, many of which do consume, well, we're going to fly your urine halfway across the country to get it tested. That's just hysterical to me.
Yeah.
Yeah,
And for multi-state employers, you might need to update your drug policies and your drug and alcohol policies to have state-specific language, or to make sure it's consistent across the board for all your employees. So it's definitely an interesting concept there.
and I haven't read the case, but again, Bo just mentioned the Walmart case before, but that was a class action, and Walmart, I think, has the same policy across, all of its states. So again, I think the plaintiff's bar in the cannabis field, may be a area of growth, as might the defense field, and Jeff and Bo may be consumed over the next several years trying to figure all of this out. Hopefully, not too many employers end up being sued. Hopefully, we can develop a great test that is accurate, on point, and all this could go away because we'll know exactly what's going on at any point in time. But I don't think we're anywhere there yet. We only have a few more minutes to go. So what I would like to do is just go back around the panel for any closing thoughts, and we'll go in reverse order from where we started. So Jeff, any closing remarks you want to make?
Very briefly, I hope we've been some help today, kind of wading through these messy waters. I hope that we've been able to provide some insight. If you have any other questions, I've put my email address in the chat. I'm going to do it again right now. And feel free to reach out. I enjoy talking about this topic. It's going to be a very interesting topic for the very near future and potentially longer. So I thank you for all your attention as well.
I'm not sure if Bo just disappeared. He disappeared off my screen.
Oh, no.
So we'll skip Bo for a second and we'll go to Chris.
Certainly. Thank you, Ray. Thank you, Jeff. Thank you, Bo, wherever you went. Just remember that the guidance is not regulation, right? We're working on the wire regulation certification process, but it is a good starting point. And we're trying to understand, the guidance is going to give employers a path to fairly assess impairment on the job. That's the goal. It's assessing impairment, and whether it's related to cannabis use or something else, assess impairment, document impairment, and then you may be able to use a drug test to take adverse employment action. But thanks again, Ray.
Thanks, Chris. So Bo, are you here? So Bo is not going to give a final comment. By the way, if we were all live virtually, there is no disappearing from the room, that quickly, unless you're a TV show. So that's kind of the benefit of doing these things, in person versus virtually. But if we cannot fit everyone in our conference room if this were done in person, so we're able to reach a lot more people. This conversation again was recorded. It will be sent out to all registrants if you were here or not. Correct, Danielle? Just I know you're saying yes in the background. It'll be sent out on Monday. So, Bo, I'm not sure where you went, but you get to make a final comment.
Again, thank you, the NJBIA, for actually trying to keep the focus on this issue. It's messy. It's not a perfect solution, but we have no choice to really address it at this point. And this is not something that is something that should be a finger pointing contest. This is something that we just need to acknowledge. This is the future. So everybody, you're professionals. You're trying to do all the right things and explore this. Understand that you need to have a talk with your HR people. Understand that you might want to change how you've been doing business as usual. So, Chris, Jeff, really do appreciate you guys having this fun conversation.
Again, I want to thank you all for doing this. Especially want to thank Chris for taking time out from standing up an entirely new industry to and the continuing work and cooperation that the CRC, you and the rest of your staff have provided to us, to the business community. We know what a hard job you guys have had. You could probably use 10 times as much staff, and you would still, have a lot more work to do. So we appreciate everything you have been doing. We look forward to continuing to work with you. As I mentioned, this is being recorded. It will be sent out next week, even if you did not attend today. If you don't have the CRC's guidance, It is on their webpage. You could just pull it off of there. I believe as well that this chat we're copying it as well, and we'll send it around to to all our speakers today so they have it. If anybody wants a list of the chat, I think we could do that as well. Just let us know. Otherwise, I thank everyone for being here today. Have a good weekend, and the advice is talk to your HR professionals, call your labor attorneys, make sure you do this right. So I thank everyone for being on today. Thank you.
Great weekend, everybody.
Take care, everyone.
Thanks, everyone. Take care.